Welcome to the Modern Arizona Podcast. We share the stories of people whose lives are shaped by the legal system in Arizona and beyond. Each episode blends real experiences, expert insights, and practical guidance to give you a deeper understanding of the law and its impact on everyday life.
Hello and welcome to the Modern Arizona Podcast. I'm your host, Billie Tarascio, honored today to be joined by Lori Basinger, works for a legal services and domestic violence agency. Coming out of her own situation, has really become an expert in advocating for the new Massachusetts laws regarding coercive control and helping people navigate reactivity in family court. Lori, welcome to the show.
Thank you, Billy. I'm so happy to be here.
That's
Thank
a
you for having
lot.
me.
That's a lot. What you do is a lot.
It is a lot. Yes, it's a lot. I'm very grateful to be able to participate in it, though, be part of it. It's
Yeah.
amazing
And
people in that field. You work with some pretty amazing people that are really committed.
absolutely. But it's so different from being a regulatory attorney, right? I mean, I can't imagine the differences in your practice since changing.
Yes, you're correct. Regulatory was very compliance based, right? If you do that, don't do this, the DEA may come and get you, or if much different, like much less nuanced, I think.
And you bring up a great point even right now. If you do this, there's going to be consequences. If you break the rules, things will happen. And then so often in family court, especially for people who are in these relationships, there are no consequences. There is no way
Right.
out.
That's right. And hence the frustration, right?
Right.
How often do we hear make it stop?
Right.
I just want to make it stop. You know.
Right. Right. And so we have these new laws. I say new. They're what, a year or two old?
Yeah, they were and passed last June and they came into effect last September. Passed last year, September.
So pretty new, and it defines domestic violence, domestic abuse as coercive control.
Yeah, includes the definition for a 209A, a restraining order in Massachusetts, of abuse is expanded to include coercive control.
Okay, so you can get yourself an order of protection. That's what we call them here. What do you call them? A restraining order?
The public term is restraining order, but the technical term is really abuse prevention order, which we like much better because
Yeah, yeah,
it's allowing the survivor to prevent themselves from being abused. It's not restraining anybody.
right.
Yeah.
Okay, so you can get this abuse prevention order. Does it impact the family law case, a custody case?
The statute itself didn't change the statute and custody. However, there is another related law that defines that the court has to look at abuse in family law and custody cases, and we can assume that the court would define abuse as the family court also hears abuse prevention order cases. So that statute wasn't changed, but the definition of abuse one would infer will be taken to be expanded there. But of course, probate and family courts in Massachusetts also hear abuse prevention. Can get an abuse prevention order in probate and family court in Massachusetts, both district court, probate and family court, and superior court. But most people don't go there.
Got it. Okay.
Yeah.
So your law practice and organization, Move to Rise, is really focused on equipping survivors with education and support and legal strategies to navigate abuse, like litigation abuse. So this is very niche. Can you talk about what that means?
Yes. So there's another. Yes, I'll talk about. First of all, I'll say that there's another piece of legislation that's currently before the Senate and the House um, to prevent controlling and abusive litigation. Because coercive control is one piece of this, but we want the survivors to have actually cause of action for courts to look at what's happening to litigants ongoing. Repeat, it's defined very clearly, and for survivors to actually have a cause of action that says, this has to stop. So, because a lot of my work has been with people who have been before probate and family court for, I don't know, years, sometimes a decade. I'm very interested in helping that group of mostly women to who have been there a long time, to create strategies for themselves to help them like get out, minimize the damage, and to move beyond, just their experience of being in a prolonged state in probate and family court. So, that will be, some of its strategy, some of its events to like move on and focus on next phase of life. And, some of it's to work with the current attorney, to kind of figure out what might be more beneficial in their case.
Okay. So it's really a consultative attorney more than
Yes,
a
really. Yeah, with a little bit of work with, you know, uh, a little direct rep for restraining orders or abuse prevention orders, but mostly consulting on their legal documents, their legal matters. Yes.
okay. What are the biggest mistakes you see people make most often?
So hard thinking that the system will change it, believing when they enter into the system um, that the system is going to see it, coming in without clearly defined agreements, because if you have an abusive party, they tend to like the shadows. So, people sometimes negotiate separation agreements that are vague with this person. And that's not a good strategy. So I feel like I always try to tell people to be as clear as possible. You want an agreement or an event that the judge can see on its face is not being met. And that's challenging for people to see if they haven't been through the system. I'd say that's number one. Another one is continuing to engage with the other party. Often people engage back and forth in conversation and emails, and that information can be used against them, and trying to make the other person change.
Yes. Um, so many people in these relationships spend years and so much energy trying to make the other person change, trying to do anything they possibly can to convince the other person to do things differently. What can someone do in that situation? They
First
want
of
it to
all,
change, but they don't want their marriage gone. What do they do?
they want their marriage to go on. Is that what you said?
Yeah,
No.
they're not ready. They don't want their relationship to go away. They love this person, but they want them to treat them differently. And they're doing everything in their power to try to make them behave differently.
Yes. So I'm not a therapist. So I first recommend people go and get help regarding that, because we know that people tend to do that when they might have had the experience in the past. And most people are doing that, based upon what the experts tell me. And what I read is that they're doing that to try to make themselves feel safe, and that this is this is what would feel safe for me to do. And sort of hallmark of that. So learning how to doing what strategies that they can, or getting the help to not maybe match the two. As far as how they could do it without going to court, how can they disengage and try to focus on what they can change, which is themselves, right? So if somebody is experiencing, let's say they're experiencing this behavior up to the level of coercive control in a marriage, and they don't want to leave, they can not think that explaining their position to the other party may change it. So if they're in this dynamic, the other party doesn't really want to change it. So if we're talking about a person who's married, the other person is coercive controller, they want to maintain power and control. They're not seeking unity in these situations, in the extreme situations. The other person can learn how to take back their autonomy. How do I still do what I need to do without trying to convince the other person or putting myself in danger? We deal with people that like stop their partner from going to work. How do you still find a way to going to work when you don't have to over explain yourself to the other person? How do you find a way to have somebody take care of the children that isn't going to be your partner? How do you find ways to make sure that, you still see people or friends or outside people that you want to see without convincing the other person that you need to do it? And then, probably creating a safety plan in the background for if your partner doesn't react well to it. But it's
Hmm.
certainly in the situations that rise to the level of coercive control, doesn't involve trying to have the other person understand, but that's easier said. People have to come to that realization on their own, don't they?
Right. So there's nothing you can do that's going to change their behavior. You can only create new supports and boundaries and systems for yourself. And then that might escalate, that might break the relationship. It might become unsafe when you start setting those boundaries and push things over to a new level. And then you're working with people who are usually in that limbo, right? They're out of the relationship technically. They're no longer, you know, together. But you still have this relationship because if you have children, you still have this ongoing relationship or this breakup. And how do you coach people during that time?
Yeah, that is extremely challenging, right? So some people are at the point that they have left and they're trying to convince. Now, in my situations, we're talking about people, who aren't probably, who are less likely for the other party to change, right? They've tried, they've left the relationship. The other person really isn't doing a lot to change. So how we coach the survivor, that's when we call that person the survivor of that kind of, abusive behavior. To We try to coach that minimal involvement as possible. So if we have a situation when somebody is, they're coming into court and they said the other party didn't want anything to do with the child, and now that I've left them, they've just filed an action for full custody. But they didn't want anything to do. So now I'm going over there and bringing the child over every day because they're thinking they can solve it or fix it or make it go away. Reasonable, normal expectations. But then now the person wants to use that, in court, saying that they want to be over there all the time. And so it's really trying to coach the person that usually the other person's goal isn't connection, it's power and control. And so although you're trying to resolve it this way, that's not what the the situation they're seeking. So we try to talk about boundaries. What can we put things in writing? Is it appropriate to just connect through text through a court approved app? To not see the person except for on drop-offs, to see like what limits is the person comfortable setting.
Mm.
And if they set those limits, sometimes the other party's behavior escalates or they want more time with the children, more. So we try to listen to what the survivor says. I do want to do this, but if I do that, they'll try to seek, more time with the children. And we respect the survivor knows best. It's always the survivor knows best. And we kind of find out where that person's at. We can give them all of the legal advice in the world, but they live their experience with this abusive person every day, and we want to make sure that their voice is the loudest, and that
I think that's really important, right?
yeah.
Everybody outside a relationship knows exactly how you should handle it, right?
Yes, that's really true. And survivors are many very, very resourceful people. They've had to live and raise their children in really extreme situations, and there's wisdom in that, right? They know, how to keep them safe. And so we can try to give them like, here, there's all of your options available to you. And when or if you're ready for them, maybe we can assist.
Mm-hmm. What does abusive litigation look like?
Yeah, so great example. I think people think of one of the most common ones is repeated filings. I think that is a more obvious one. Somebody goes into court, an abusive party goes into court, maybe, again, great, says they no perfect classic one you might see, no involvement with the child. The survivor gets files, might not even be married. They leave the relationship and they abusive party goes in and files for custody. They may also go in at the same time and file an abuse prevention order against the survivor. They may also go in and take file an action in housing court to get the person evicted. So sometimes those are the more obvious ones, right? Somebody uses the court system as a weapon of control. They use them a weapon. That's a pretty more. I'm not saying the court see this as obvious, but it's sort of more like direct. You can point to it. Maybe they just go into probate and family court and they get an issue resolved. They file custody, and the next 2 months, weeks later, they file another action to modify. And for the most part, the court allows that in. They don't. And maybe they file actions to have the judgment overturned, like repeated court actions. Those are most common. Another sometimes less obvious one, but not are like non-compliance with court orders. So they're ordered to pay child support. The abuser's ordered to pay child support. They don't, again and again and again. The more direct is they don't pay. More indirect or more likely is nuanced. Like, I lost my job. I can't get in here this day. Something happened. Of course, there are instances when this really is legitimate, but we're talking about a repeated pattern of non-compliance. You know, they somebody these somebody continually changes the health insurance. Somebody
Mm,
continually, doesn't pay for the college bill. Because when all these things are been agreed and negotiated, and they can repeatedly don't comply. Those ones are a little bit more hard for the court to see than the direct, like aggressive, filings against the other party. Not producing discovery. In the middle of a divorce, you delay and delay and delay, or use discovery to just torture the other party, right? I mean, so these are like you make sure the other party doesn't receive payments, so they have to move out of their housing.
yeah.
You know, go on public assistance. Continue to go back for so many examples. Continue to go back for asking for unification therapy. There's
Mm-hmm.
just, and sort of the challenge will be if the statute passes is like, how do you get what's, regular, like,
Well,
you know,
right. That's the
what's
question.
appropriate. Yeah, that's going to be that's the challenge. As I said, the first example of repeated filings in 3 different courts might be more obvious. And hey, I just want to reunified with my, child and my family might be a less obvious example. But if it's done in a pattern to repeatedly like harass and intimidate and control the other party, that will be the lawyer's job if this passes, to try to get the court to kind of see, you know, what
I
it
mean,
will
because really,
actually.
really, you have to prove their motivation.
You kind of do. You have to say, yes, it's the
That
intention,
they're
right?
not filing for custody because they broke up and now, this person no longer has access to their children and they need the court to give them access, which is perfectly legitimate. They're doing
Right.
it for some other reason. It's how is that even, how do you do that?
Yeah, I guess, where it's going to be the, right now, well, the statute, the bill has a very clear like method. And so I guess you will have to show proof and, show that there's a pattern. There'll be requirements. Again, it hasn't passed. But right now, the survivor has to go in, if you're in probate and family court for a number of years and the person maybe keeps doing a repeated pattern, they have to address the issue as if we're really talking about, health insurance, right? Somebody's non-compliant with health insurance and you have to go in and say, oh, there really isn't any argument that you can have except for they're doing this to like harass me, but the court directs it to health insurance. So at least this would be an option for the attorney, for the pro se litigant or the party with their attorney, to make the argument that this is actually intended to harass and intimidate
And it's
and lay
prohibited by
out.
law. Yeah,
Yeah, and it
very
would be,
helpful.
and the court would be required to look at it, not just say, because Massachusetts courts have said, hey, we have the ability to do this now, but they're not. And
Okay.
understandably, they have a lot going on. Everything's very transactional, as you know.
Mhm.
This would actually require them to actually have to delve into some kind of
Mhm.
more of a like look deeper dive.
I want to ask also, so coercive control is also one of these things that I feel like is very, very difficult to prove and very easy to explain away. Very, very difficult to explain the totality of the circumstances when it's broken down into examples that are easily explained away. How is that playing out in the courts?
Absolutely. Oh, this is something we are talking to people about every day. You have the person who does have has had physical violence or a threat of physical violence and coercive control, and we always suggest that survivor focuses on physical first and then explains coercive control next, because right now courts see physical violence, much more clearly than they do coercive control, of course. So are we seeing a lot of abuse prevention orders for coercive control only? No. Some, but maybe ones that are involve more physical like control. That's a horrible explanation, but like something like stalking, or see, but the court something might see it a little bit more as abusive versus isolation, or
Yeah,
financial abuse.
right.
So the Massachusetts requires a pattern. So we're trying to help clients kind of show what this looks like as a patterned behavior and how it impacts their life and they're controlled and how it's abuse. And it's hard for the courts to see that now. We encourage clients when they can, if possible, to get like an expert, like, Massachusetts, like Lisa Fontes is in Massachusetts, does a lot of this work. Even if the expert doesn't look specifically at the facts of their case, but
Mhm.
can kind of explain what coercive control looks like in practice. So you have somebody that's not, the court user or the attorney explaining what coercive control actually is, and then fitting the fact the attorney can fit the fact patterns. And right now, the short answer is it's an education process for judges right now, right?
Yeah,
They're being
yeah.
educated by litigants, and we're not quite there yet. I can't give you 20 examples of people who've gotten a restraining order simply for coercive control.
You are involved in legislative advocacy, helping create these laws. Are you also involved in the aftermath of teaching the judges?
Um, we are in the sense that we get we're like, yeah, I guess I worked like in groups on bench cards. So yes, so after the law, after the course of control law passed, when it was in the process of, finalizing, there's a group that worked on like a bench card and education. This is what it looks like for the judges. So yes, there are people who have done a lot of CEs on gone to kind of judges conference. There's a woman, Jamie Sabino, who's kind of led the charge and has been leading the charge on this for years. She did a lot of that work, but there's groups that support her, and I've been part of those groups.
Wonderful. What are the current biggest legislative priorities from your point of view?
Number one, passing abusive litigation. So that has been, there has been a big testimony day at the State House. We have had groups of women testifying before the Senate Judiciary chairs, before the League of Women Voters, trying to get the message out and support for abusive litigation and letting people know how often this happens. Huge. That's a huge priority, and one that kind of like it's daily work, trying to get the word out. There's also a bill in Massachusetts on coerced debt because abusers frequently get their victims into debt situations,
Yeah,
either
yeah,
knowingly or unknowing. That's a big piece of legislation that's passing,
wow.
hopefully passing. Yeah, that's moving forward. Hopefully passing this year. But trying to get people to see that the coercive control legislation that passed last year, although extremely helpful, was not it was just the start, right? That's just like
Mhm.
letting us understand what abuse really is, but that's not all there is. That there has to be more of a ability or action to try to have courts like take action to get involved, because nobody should be in court for, years, never 10 years or years and years and we need some more awareness about it.
You're right. People in family court can be in court for the length of their children's existence and sometimes even longer.
Had a case that the woman was in 25 years of the abusive person. She had a restraining order, a permanent restraining order, continuing to challenge it. So, yearly seeks a modification. The opposing party seeks a modification, and then she has to go back and defend it because it was severe abuse. And, the party still has the right to go seek a modification. And, there needs to be some more stopgaps in that process.
I think that's an excellent example of like, you get to challenge it 3 times if it's a lifetime and then you're done, right? I think that's an easy rule. Easy. Um, but for cases of custody issues, best interest issues, that's a lot harder. What would the law look like to address that?
We have some obvious instances of abuse, right? I mean, the court system, as we know, is very still focused on that both parents should be involved. And is
Mhm.
that, and we have to really challenge our assumptions about that, right? If one party physically assaulted, and this is should be more obvious case in my mind, physically assaulted the mom in front of the children, and then can be back, a year later asking for unsupervised visitation. I mean, should we even entertain that motion? It doesn't mean they can't maybe see them visit, with supervised, but I think we have to challenge our assumptions, and that hopefully having the ability for the court to have to hear this, to make these arguments to the court, or, when there's, alleged or proven sexual abuse of children, we have to have different standards and different assumptions. And I think this puts it in the hand. If this bill should pass, the courts will have to actually look at these cases. It doesn't mean they're always going to agree with the survivor, but they'll
Yeah.
actually have to give some more attention to the issue.
Yeah. I love that. Talk to me about your Beyond the Courtroom Healing Advocacy and Coercive Control class.
Yeah, so I'm going to try to have women through retreats and sort of online experience thinking about what they want for themselves beyond the abusive relationship. So as we said, so much of this dominates a survivor's lives, because of course it would. But there is life outside the court, even when it's going on. How Getting people to focus on, or survivors to focus on, areas of their life that they want to take back. Maybe it's that they want to focus more on therapy. Maybe they want to focus on what they loved before. Having a forum and a community and experience to actually focus on themselves with people who understand what they're going through. In no way you're minimizing this, like, really, really tragic situation they're experiencing. But anytime we can take the focus off the abusive party and focus back on the survivor and what they want for their life, that's where I want to be, and that's where I want to help, people in recovery from abusive relationships be.
Where can people find your program if they're thinking to themselves, that's me. I really want to move forward from where I'm at. I want to stop thinking about my ex and start planning my future. Where can they go?
Great, thank you. They can go to my website, which is loribasinger.com. So Bassinger. Thank you.
Lori, thank you so much for coming on the show. Any last words you want to impart upon our listeners?
Thank you. That there is always somebody out there who understands, because when you sometimes try to talk to people who haven't experienced this, it's almost unfathomable that a court wouldn't stop this, but they will find their people, and to just make sure that they find the people who have been going through this, and they are supportive and they can relate and help.
Thank you so much, and we'll see you again soon.
Thank you.
Thanks so much for listening to the Modern Arizona podcast. If you've enjoyed what you've heard today, make sure to download it, like it, leave a review, and share it with your friends. If you know someone who would be a good guest, or you would like to be on the Modern Arizona podcast, make sure to give us an email or reach out to us at mymodernlaw.com.